Section 21 is dead. And if you are a landlord in England, right now, there is only one route left to get your property back: Section 8, and most landlords are not ready. Welcome back to the Renters' Rights Act 2026 Complete Landlord Guide. I am on episode 5, and today we are breaking down everything you need to know about Section 8, your only legal route to possession. Now that Section 21 has been abolished, let us get into it. Section 8 comes from the Housing Act 1988. It gives landlords a legal framework to seek possession through the courts, but only if you can prove a specific ground. Before the Renters' Rights Act 2025 came into force on the 1st of May 2026, landlords could use Section 21 to evict without giving any reason at all. That is now completely gone. Every single tenancy in England has automatically converted to a periodic assured tenancy, and from this point forward, every possession claim must be brought under Section 8 using one of the prescribed statutory grounds. There are two types of Section 8 grounds: mandatory grounds, where the court must grant possession if you prove the ground, and discretionary grounds, where the court decides if it is reasonable. Prove your ground, or the court says no. The most important ground for most landlords is Ground 8, serious rent arrears. This is a mandatory ground, meaning if you prove it, the court has no choice but to grant possession. But the rules have changed significantly, and you need to know this. The threshold for Ground 8 has been raised. Under the old law it was 2 months arrears. Under the Renters' Rights Act it is now 3 months arrears for monthly tenancies, and this must be true both at the date you serve notice and at the date of the court hearing. If your tenant pays the arrears below 3 months before the hearing, even by a small amount, your Ground 8 claim fails completely, and you start again from zero. Once the court grants a possession order, the tenant must leave by the date set out in that order. If they refuse to go, you cannot remove them yourself. You must apply for a warrant of possession, and bailiffs will carry out the eviction. County courts across England are facing significant backlogs since the abolition of Section 21. Some landlords are reporting waits of 8 months or more. Section 8 rewards only those landlords who get every single step exactly right the first time. If your ground is Ground 1A, intention to sell, you cannot use this ground within the first 12 months of the tenancy. This protected period stops landlords removing tenants too quickly. You must give a minimum of 4 months notice, and once you have used Ground 1A, relet or remarket the property for 12 months. Afterwards, misusing this ground without genuine intention to sell is a specific offence under the Act.